as a wholesaler in Jacksonville, I have been dealing with squatters for the past 10 years. And I was super excited to see that Governor DeSantis has passed a bill that is changing up the process on kicking squatters out, right? And so whenever things like this happen, no one kind of really knows what it means, right? And so that's what we're here tonight for, right? Let's get an expert to share with us what they know about this change and what is good about it, what's not good about it, what makes it different, what's still gray area, what's still unclear, and then we'll kind of open up the floor for a Q&A. So yeah, that's the purpose of us doing this. I'm here to learn. Everybody should be ready to take notes in case you ever need to deal with some squatters. So Duane, let's just get right into it. What exactly is the process right now to kick out squatters?
Well, right now you have Florida Statute Chapter 82, I believe it's .035 is the kind of the go-to statute. And it's very similar to the new law that was passed by House Bill 621. So House Bill 621 is the new law that came into effect. I will call it the squatters law. It's actually the limited alternative remedy to remove unauthorized persons from the residential rental property. That's the actual name of the statute. I will call it the Squatters Act. So with that, but what House Bill 621 did, it actually made some changes to Chapter 82 to make it a little easier to get the police to respond and do what they needed to do. It also put some teeth into some of the criminal statutes. So if you, for instance, if you submit a forged deed, it's a second-degree felony. So, punishable accordingly. There's some pretty heavy penalties now for people that are committing fraud in this area. So essentially, the new law, the difference between the new law and the old law, the law that's on the books now, is the difference between two words, may and shall. The existing law says you can go down to the police department right now and give them an affidavit that says these people are squatting in my property, and the police department may take action to remove them. And oftentimes they may not take action to remove them. They say, you know what, it's a civil matter. We don't have time for this. We're not going to get involved with it. This guy's saying he's there under, lawfully there. Go hire a lawyer. Good for lawyers, not good for homeowners or investors because it costs money to hire lawyers. The new law says shall. So in the event that you follow the statute and you follow certain procedures prescribed in the statute and swear out a complaint under penalty of perjury, then they shall take action and put that guy out. So that's the difference between, that's where we're at now. Both laws are still on the books. It's still the may I, can I, may I, or shall I provisions. The bigger issue for you as a person that might use that law is if you're wrong. If you say this person has no right to be there, they have no valid interest there, you check all these boxes on the complaint, which we can go through in detail at some point during tonight's speech, and you're wrong, you may be liable to damages for these people that the police put out on the street. So, God forbid that person actually did have the right to be there, and you weren't aware of it. You could be in some trouble. And I was telling Gonzalo earlier, I don't think that a lot of the people in this room, from what I understand about Jax Real, a lot of you guys are existing property owners. You've owned your property for many, many years. You know for sure you did not give this person the right to be there. It's the newer investors, or maybe you bought something at a foreclosure sale, or maybe you bought something through a wholesale deal. You're dealing with a seller. You think that you know who these tenants are, or there aren't any tenants, and you're relying on somebody else to tell you what the status of this person is. Then you go buy the property, then no problem, to go fill this affidavit out, give it to the sheriff's office, and then suddenly you're wrong. So that then puts you back into the other provisions of the current law. So you have ways to get people out now. You have what they call an ejectment action. You have what they call an unlawful detainer action. And of course, you got your old-fashioned eviction. And so those are on the books now, but they do take time. They take lawyers typically. And in some cases, depending on how you own your property, you can probably do those complaints yourself. But typically people hire a lawyer to push that through the system.
Awesome. So I want to take it a step back.
Okay.
right? So you mentioned right now cops may or may not get involved, right? So um, when you're saying cops may or may not, and they say go the civil action, right? Civil action means those three things: eviction, unlawful detainer, and ejection, right?
Ejectment,
So
yep.
ejectment. So can you give some sort of like quick summary or process of each of those?
Yeah, so ejectment, for prime example, is you've got somebody that's there. Let's say they had a purchase and sale agreement, an agreement for deed, and they're not just a tenant, they're not a squatter. They actually have a document, legitimate document that says they have the right to be there. It's basically arguing over title. Who has the right to be here? Sometimes it involves heirs or beneficiaries from an estate, and so it's not. They weren't. They were there for some reason because they had a document so they could be there, not a lease. Then you've got unlawful detainer. Classic example, I think I talked to somebody earlier today, would be boyfriend and girlfriend. You know, got a girlfriend moved in, she won't move out. Ask her to leave nicely, she won't leave. She got her stuff there. That's maybe unlawful detainer. Or you know, you let a friend come to your house, stay at your house while you're out of town, and they just won't leave. There's that. And then of course you've got your eviction actions under Chapter 83, which would be your typical either written lease, oral lease, even an expired lease. So there are things you can do.
Okay. And so what would be the process now to kick out a squatter? It would be like, which one would be the better way out of those three to kick out a squatter? And then how does that compare to what could happen now?
So unlawful detainer is found in Chapter 82, and this new law is also in Chapter 82. So it's essentially what you're doing is an unlawful detainer action is a lawsuit. This is a provision of the statute that says you don't have to file a lawsuit if you fill out this detailed affidavit. Basically, hey, I'm the owner. This guy has no right to be there. They're not a former owner. There's no written agreement with these people. And you fill all this stuff out and you file this complaint and you give the complaint to the sheriff's office. Then they just go out and serve it on the person that's there in the home and put them out. I've been trying to call JSO for the last couple.
Real quick, what does put them out mean in this new law?
Well, in this case here, they would physically. It would almost be like, you know, after an eviction, they serve you the writ, and you go down there and meet the police officer there, and they put the person out. Same sort of process. Although this is a new law, it's not even in effect until July 1, and we're still kind of feeling our way along. I can't tell you for sure exactly how JSO is going to interpret it. We've called them a couple times. There is some information on their Facebook site, JSO's Facebook site. I called today before I came here to see if they'd put their complaint up. They're supposed to kind of promulgate their own complaint that you'll fill out and sign under oath and then deliver it to the civil process unit. Once they do get it, I think they still charge you the same writ fee. So was it $90 or that you still pay that same fee to the civil process unit? The difference is they're not waiting for the court to give a judgment of eviction or what have you. They're skipping that part. That's the important thing. They're going to skip that whole judicial process. You don't need a lawyer to do this. You go down there, you download the complaint, and you check the boxes, make sure you are accurate. And the nice thing about it for the police is that because the statute says they shall do it, it also says they're not going to be liable if they put the wrong guy out. You're liable. You as the person that filed the complaint.
Got it. So, what do you think is going to be some gray areas with this, right? So you're talking about like making sure you are properly kicking out the right people, right? What are some other potential gray areas with this that we should maybe be cautious with?
I think the biggest thing I see, again, going back to who is the owner? Is the owner a guy if you own the property for 25 years, and you know for sure you didn't sign any lease or deed or anything with this person, you can feel fairly confident filling out that form that says, I know this guy has no right to be there. I want them gone. You fill out the box. If you just bought the property and you really didn't know the owner and you didn't go down and speak with this tenant in person or this person in person, squatter in person, you're taking a risk. And I was just sharing a story. I have a client that does what a lot of the people in this room do, and he came to my office after a closing at another place and said, "Hey, I need you to do an ejectment." I think it was it was an ejectment action. No, actually, take that back. He wanted me to do a eviction. So we gave the guy, "Hey, your note, here's your notice. Your month-to-month tenancy's up. You got to go." We filed a suit. That guy hired an attorney and alleged that all of the deeds that my client relied on in the title company and title agency that closed the transaction were fraudulent. And so now we've filed a title claim for him with the title underwriter, which eventually they'll give him some relief. But right now we're stuck in court. We have to go back. We have to modify and amend our complaint to allege that for ejectment, because we're not just going to give up and say, sure, the deeds are fraudulent, but they might be. And that's what judges are for, to tell us whether those deeds are fraudulent or not. So that guy is now stuck. He can't sell the property. He can't occupy the property. Eventually, I think the title insurance policy he received will pay for lawyers for him to take charge, and probably pay money if it turns out that these guys are right. The occupants, their deeds were stolen. The property was stolen from him. He'll get a check for whatever he paid for. Now, as some of you guys may or may not know, a title insurance policy typically doesn't cover the interest you paid on your loan. It doesn't pay for your lost profits on the money you didn't make while you weren't flipping that thing, if that's what your business is. It just pays your purchase price back, and that's it. So that's what I'm seeing. That's the biggest thing I see out there that people need to be a little concerned about when you're buying a property. When there's somebody in possession and they're there when you get it, you really need to knock on the door.